Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today we're going to look at what happens when a lawyer goes sovereign citizen, or OPCA as we tend to call it in Canada after the Meads and Meads decision. So what's going on in this case is that a lawyer, Naomi Arbabi, is suing a neighbor or somebody in her neighborhood, Colleen McClelland, and the issue is a privacy fence that is blocking the view. Now, that's not where things get interesting. Where things get interesting is that Ms. McClelland has alleged in her response that this is basically a sovereign citizen argument. And this was reported on by several places, including the CBC, and I thought, this can't have much to it. I mean, there's a lawyer involved. Well, this is going to be a Scotch video, so let's have a look at this one. All right, so this one starts out in the Supreme Court of British Columbia, the woman, Naomi Arbabi, and the woman, Colleen McClelland. Now, this is not typically how you start a lawsuit. You would just say the person. And I'm noticing an absence of capital letters. I don't know if that was intentional or what, but it continues on. So, claims of the plaintiffs. So, now you're going to hear this and you're going to think, oh, legal language is so obnoxious. This is so unpleasant to listen to. Because why do lawyers have to talk like this? And the answer is this is not legal language. This is just bizarre. So part one, statement of facts. I, a woman, claim, I believe the property of I is what is proper to I, exclusive of all others within the society, and I claim the apartment located at redacted. Now I'll note that some of the other places reporting on this did not redact the address. Why? Vancouver, British Columbia, including but not limited to all its aesthetic appeals in form of its breathtaking views of the ocean, the mountains, the bridges, Stanley Park, and more as the property of I. Now, here's where we're already running into problems, which is that you don't actually own your view. And what I mean by that is that you might have a beautiful view of, say, Stanley Park. Well, the government has control over Stanley Park, and if they decide to change it from Stanley Park to Stanley Garbage Dump, that's the government's call. The bridges, the same thing. All sorts of people might have buildings that are part of your view, and they have property rights over that. She doesn't own the ocean. She doesn't own the mountains. None of that is actually her property. So I claim that a woman, Colleen McClelland, after being noticed, does knowingly trespass on I. Now, the noticed here means that she gave her some form of like legal threat or legal warning, and we'll get some inklings as to what that is. I don't have the full notice, but we'll get some indications as we go. I claim the trespass comes by way of loss of enjoyment and loss of value of the said property of I, and administering the property of I without right or consent, and these trespasses do and does cost financial loss, loss of property, enjoyment, and stress. Those are bad things, but not everything that causes you stress or loss of enjoyment or anything like that is necessarily a legal claim. So, what is the issue here? Well, I claim that commencement of the trespass began on September 5th, 2023 at approximately 10 a.m. when the woman, Colleen McClelland, caused to be installed a 66.5-inch tall privacy wall at the border of her part of the rooftop deck, which is shared with I and two other neighbors, thereby blocking the view of the ocean, mountains, Stanley Park, bridges, and more from the property of I. Okay, I can see why she'd be upset. You know, she has this beautiful view, and then suddenly this privacy wall goes up, and she can't see a thing anymore. Well, the problem is you don't actually own your view. The neighbor owns their property and can build a privacy fence on it if that's allowed. And in fact, there is some case law on this. You know, if we're looking at what does the law say? So I went looking, and there was a few different cases I found, but a lot of them weren't all that clear because there's not a lot of litigation on this because it's considered pretty obvious. How obvious is it? Well, here was one of the cases. This is the Grant case. And they have the defendant built their home in a way that it unreasonably obstructs or interferes with the plaintiff's right to light. This was one of the claims. And so they note the main complaint which Mr. Grant and Ms. Doran have with respect to the Warman property seems to be that it blocks their view of Discovery Passage and thus restricts their enjoyment of their deck in particular. However, Mr. Grant conceded that there is no cause of action arising from blocking of the view. Okay, so this is a case where that was their main complaint, and when they actually got to trial, they had to admit that's not actually a thing that we can claim for. But that's not super useful for us because that doesn't really decide the law here, right? So then we can look at another case, and this one is a little clearer. This is Christenson and District Highlands. So they talk here about nuisance. They say the interest in the beneficial use of land protected by the action of nuisance is a broad and comprehensive notion. Now, nuisance basically means that your neighbors or other people are not allowed to have stuff leave their property and ruin your property. So they describe this, they say, accordingly, harmful interference may be manifold. It may consist in physical damage to land, buildings, and chattels through vibrations, flooding, fire, and the like, in disturbing the comfort, health, and convenience of the occupant by offensive smell, noise, smoke, dust, by telephonic harassment or fear for one's safety or health, or only by affronting the susceptibility of reasonable neighbors by a house of prostitution or a sex shop close to a residential area. I don't know if those ones would even hold up at this point. This was a 2000 decision. But, so what this means is if I'm having trash fires in my backyard and the neighbor can't use their property because smoke is leaving my property and coming onto theirs, they can sue me for nuisance. But nuisance doesn't extend that far. There's limits to it. And so the court continues to say, not all amenities, however, commonly associated with beneficial use of land are vindicated by the law of private nuisance. Not aesthetic values, like an unobstructed or pleasing view from one's home, or against an isolation hospital from moving in next door. Nor such privacy values as freedom from being spied upon from a vantage point, not even an absolute right to light or lateral support for one's buildings. The erection of a building interfering with TV reception has also been declared immune on analogy with loss of prospect, as otherwise imposing too great a restriction on development in cities. So why is this the case? Well, you own your land, just your land, and you don't own the neighboring land. So if you had a right to keep people from building structures that block your view, then essentially you're exerting a property right over the neighbor's property. My property is 1 story tall and I have a great view, therefore you can't build anything on your property because it would block my view. Well, suddenly the neighbor's property isn't worth a whole lot because you can't build anything on it, right? So the law says you don't have a right to these things. You don't have a right here because it essentially would be a right to prevent other people from exerting their own property rights. And it becomes really a matter of who builds a house first. Now, there is a way to get a right over this. If you have such a concern about your view, what you would need to do is approach everybody who owns property between you and whatever you want to see and get them to agree to basically encumber their property, agree to a restriction on their use of their property for your benefit. And that would cost you a whole bunch of money. But you could do it. I mean, if you had the money. And if you don't have the money, then you don't get to tell the neighbors what to do. So I mentioned that we were going to get a little bit of note or a little bit of detail about what these notices were. So that's where we're going to go right now. So relief sought. That said, I now require compensation as per the notice sent to the woman, Colleen McClelland, on September 28th, 2023, which totals $30,000 for the 30 days as of the date of this notice since the trespass started, plus $1,000 per every additional day until trespass has been remedied by the court. So she sent her neighbor a notice saying, you're going to owe me $1,000 a day for having this. And I don't see a basis for it because, as mentioned, the law says no. Plus administrative cost for the notices of $4,200 as of the date of this notice, plus court fees and other expenses. Now, I'm sometimes it might be reasonable to have some sort of administrative cost, but I'm guessing these were just notices printed up on a home printer and that weren't like hand carved into blocks of gold by celebrities. How do you get to $4,200 on that? I don't know. Alternatively, I may accept at the sole discretion of I anything of equal value which may be offered as compensation. I think you're not going to get offered a whole lot as compensation. Just pro tip. So, legal basis. This is a claim of trespass by way of loss as pressed by a woman, Naomi Arbabi, against a woman, Colleen McClelland. And here's where things start to get really bad. Really bad. This is a claim based on law of the land and not a complaint based on legal codes, acts, or statutes. All right. So, you're a lawyer and you're bringing a claim based on not legal codes, acts, or statutes. Based on the law of the land. Okay. I guess instead of taking this to a courthouse, maybe you should take this into a forest and serve your notice on a bear. Because the law of the land, I'm sorry, what the heck? This is where we're pretty clearly getting into the hints of sovereign citizen kind of stuff. And it's going to go from hints to like glaring red, flags with alarms and everything. We're going to get real bad real fast. So, I state I did acquire my property at a time when a much lower clear glass divider that was installed previous to this 66.5-inch wall allowed the addition of the aesthetic appeals of the said views to the property of I, and I did rely on views in making the decision to purchase the property of I and in negotiating a purchase price for the property of I. And that's your problem, and that's on you. Because ultimately, you don't own those things, and if the court, you can't go to the court for a remedy there. Sure, you might have paid a higher price, but the value of your land can go up or down based on what other people do with their land, and that's just the nature of owning land and not owning your neighbor's land. I state I did conduct due diligence searches to inquire about the conditions of the property of I and the neighboring properties, and did not find any evidence of the woman, Colleen McClelland, having the right to block the view of other properties behind her property. Well, I found it just from going to law school and taking torts class. She might have found it in the 5 minutes of legal research I did to make this video. She doesn't need some special right to block the view. That's just part of owning property. Therefore, the woman, Colleen McClelland, is stopped from asserting a right to install such a wall on her property that will block the view from the property of I. Okay, now I said that this was going to get way worse, and it does, because we just scroll down to this, Notice of Requirement of Court. And this is not a document that you would usually find attached to any legal finding, because it's bizarre. So, greetings to the man or the woman who at times acts as the clerk of the court. That's a weird phrasing. I am grateful for your time, your attention, and your services. I, a woman, Naomi Arbabi, say at the time when those of mankind trespass on the rights of I, and in doing so, instead of providing remedy, they knowingly hide behind the complexities of the legal system. Well, I mean, that is what people do. They rely on the legal system to defend themselves. And, literally, you are a lawyer. So, where do you get off throwing that particular rock? It is time for I to come forward as a woman present in honor to seek remedy by opening a case to press this claim of trespass against those of mankind I believe have done trespass to I. Man, this is obnoxious. So, I say after many attempts to keep this private and to operate as a woman with rights, no remedy has been given, and instead only more wrongs have been committed by way of threats, extortion, and barratry, which if carried out, I say amount to abuse of the legal system. Now, this is where things get ironic. What does barratry mean? Well, barratry is the bringing of basically frivolous claims in order to harass and annoy somebody. Once upon a time, it was a crime in Canada. It's been eliminated along with almost all the other common law crimes. The only common law crime still remaining in Canada is contempt of court. But when we start looking at like which claims are frivolous, this looks pretty frivolous to me. And say amount to abuse of the legal system. Yeah, this letter amounts to abuse of the legal system. Let's carry on here. This has led I to now require a court of record to press a claim of trespass and to present I before a man or woman who is competent of property and trespass law, there to keep the peace and put forward the orders of Naomi Arbabi Court. You don't get your own court. There's just one court. There's no like Ian Runkle Court. And that's a good thing, because Ian Runkle Court would probably be a crazy place with all sorts of crazy rules. Naomi Arbabi Court certainly seems to be. I wish to press this claim on a woman I believe knowingly continues to trespass on the rights of I, and whom I have noticed of this trespass. Okay. Noticed of this trespass. You know, just because you send somebody a notice, it doesn't actually mean anything in many cases. Now, there are some exceptions, but this doesn't seem to be one of them. For the sake of clarity, I will not be appearing or representing as a member of the Bar Association. That's not really an option. When you're a lawyer, the court will always recognize that you are a lawyer and hold you to certain standards, which say things like, don't do this, don't do this. Or under any surname or as a civilian, and I will not diminish the status of I to any legal titles such as, but not limited to, lawyer, pro se, complainant, plaintiff, or claimant, which she is. She literally put her name under the plaintiff thing on this form, but she's also a lawyer. She's also pro se. Yeah. I will be present simply as a woman to press a claim of trespass. I simply require room to move this case through the court, and I choose to be present before a court of record under oath, there to testify with facts to support a claim of trespass. I require no legal advice. Press F to doubt. And no legal forms, as I am not present as a member of the Bar Association, and this is a claim, not a complaint. Yeah, that's not how this works. That said, in order to move this claim through the Naomi Arbabi Court in a timely manner, I may agree in good faith to use your forms with variations noted within the forms, or as described in a notice such as this, or other attachments to fit the circumstances of this claim, but they should not be construed by any man or woman as the submission of I to any legal titles, legal codes, acts, or statutes. Well, these things don't actually require your agreement. Like, the law exists whether or not you agree to it. You can't just be like, I don't want a law today. Especially not if you are a lawyer. For any requests or concerns, please call redacted or email redacted. I say herein and verify in open court, all be true. I am just going to say it's really a bad idea to put your phone number and your email address into an official court filing, but I don't know if those are her home number or what. But yeah. And I mean, there's times when you have to do it, but I hope those are her business numbers. Anyway, rules of court. I, a woman, Naomi Arbabi, will be present to press a claim of trespass under oath at the Naomi Arbabi Court on the date scheduled by the clerk of the court at the Court of British Columbia Supreme Court. Again, there is no such thing as a Naomi Arbabi Court or an Ian Runkle Court or any of these things, because that would be crazy town. I require the man who at times acts as a judge or magistrate to give his oath to the following at the Naomi Arbabi Court. I, state your name, give oath that I will be true to serve those of mankind in the office of judge or magistrate, and I will do right by all manner of mankind, and uphold the law, there to witness a claim with facts to support said claim, and to render a verdict without fear, favor, affection, or ill will, so help I God. I God. The grammar on that made it a little blasphemous, but you don't get to tell the judge what oath they're going to swear. That's not how this works either. I require a court of record for the Naomi Arbabi Court at the Court of British Columbia Supreme Court. I require every man and woman summoned to give oath to testify to what is true under penalty of perjury. But if it's only enforceable by the Naomi Arbabi Court, who would care? Because that's not a thing. This court will not accept any legal arguments, codes, acts, or statutes, as this is a court in law based on the law of the land, and therefore a presumption of contract does not apply to I. Again, not a thing. Unless your judge is a bear, or a squirrel, or a wolverine, in which case your legal remedy is probably to get your face eaten. But, yeah. This court is to be private. It's not, though, and we're talking about it now, and we're going to keep talking about it. I say if the woman summoned for trespass does not have a lawful excuse for the trespass or claims to the contrary, and the man or woman acting as magistrate or the jury has the findings of facts and conclusions of law on the record to make a verdict in favor of I, not going to happen. The woman who now presses this claim, then the orders of the Naomi Arbabi Court are to be enforced, and the orders presented before said court to be tendered to the clerk of the court with the final verdict. The orders binding bear the seal of the Court of British Columbia Supreme Court. So you want to have the enforcement powers of the British Columbia Supreme Court, but you want this to be heard in the fictional imaginary court. Pick a lane. Upon it, and it is to be carried out in 21 days of the verdict. I say if the man or woman or clerk of the court believes it is not possible to proceed in this lawful manner, then the Naomi Arbabi Court requires their findings of facts and conclusions of law on the record to prevent trespass on a case. I say herein be true, and all herein be true, and will verify at open court. Signed, Naomi Arbabi, a woman. Okay, so that's our claim. And then there's a response to it, and I'm going to go over the response real quickly because we don't want this to be like 3 hours. But Naomi Arbabi and Colleen McClelland, and the response is basically, now she puts in the woman, and I think this is probably because she's assuming that she's dealing with a lawyer and that therefore the woman must be required, but it's not. To the extent that Colleen McClelland, like, if I had to guess which of these documents was filed by a lawyer and which was filed by somebody who wasn't one, this is the one I would say was filed by a lawyer because it actually references some case law and is not bizarre. But this whole the woman thing should have been left out. But we can basically summarize this in 3 lines. 1, the notice of civil claim discloses no reasonable claim. I agree with this. 2, the notice of civil claim is unnecessary, scandalous, frivolous, and vexatious. I think they make a pretty good case for that just on the face of the notice of civil claim. And 3, the notice of civil claim is an abusive process. Again, it looks pretty bad to me. And they cite some case law to basically say, hey, this is, scandalous, vexatious, or frivolous, and that therefore it should be struck out. Okay. So the next thing that they do is that Ms. McClelland files this, a notice of application. And the notice of application, she's asking for a few things. And again, this is something that looks like it could have been filed by the lawyer in this matter. It's not perfect at all, but it's, it's fine. So they're asking for an order striking out all of the plaintiff's claims, such further or other relief that this honorable court may deem appropriate. This is something that you usually put in. Basically, court, if you're willing to give me something else, I want that thing. Don't not give me the thing just because I didn't ask for it specifically. Full indemnity costs on this application payable forthwith, which is basically I want money, and a court referral of complaint to the Law Society of BC. So saying not just I want to complain to the Law Society as Colleen McClelland, random citizen, I think the court should file a complaint. and I think they may get their remedies. So, um, yeah, uh, this is basically a whole bunch of, issues there, but essentially there's an argument over this divider. And so the original divider, so there was a privacy divider initially, and it was removed and disposed of by the owner of another lot without approval. It borders her lot, but he's not party to this litigation. So because of that, she built a new privacy divider, which seems like the ordinary thing to do if you want a privacy divider. She's also citing and noting substantial indemnity costs awarded to defendants in a claim that made pseudo-legal arguments, which is, this is proper to ask for if you think that somebody's making pseudo-legal arguments, which is what this appears to be. The courts in the case of Meads and Meads, as well as other cases, many other cases, some of which I've covered on this channel, have basically said that when somebody makes these kinds of arguments, the court is entitled and to some extent required to punish them for it. So let's keep going, because there's a response to this, and this response gives us a little bit more insight into this whole battle, right? What's going on here? What is crazy? Why is this happening? All right. So application response. This is the response to the application to throw out the claim. So she notes that she viewed the property with an intention to acquire it. I state at the time that, I keep trying to put normal grammar on this. Like, my brain wants to normal grammarify this, and it doesn't have normal grammar. So that's incorrect. I'm reading it wrong because my brain wants to make it not as weird as it is. So I state at the time I did view the property, and for more than 2 years after I did eventually acquire the property at low height, clear glass divider, which did look to be installed professionally and permanently, as it was screwed to the wall and / or floor of the deck, was installed where the woman, Colleen McClelland, did later cause to be installed on September 5th, 2023, a 66.5-inch tall opaque glass and steel frame divider. I state before making the offer to acquire this property, I did review documents relating to this property in order to find out about any potential problems that this property may have. Now, she's saying I didn't see any potential problems, but that doesn't mean you get to control your neighbor's property. Let's imagine this isn't a privacy fence. Let's imagine that Colleen McClelland gets into woodworking and she wants to build a wood shop. Well, so long as the bylaws and so forth allow for the construction of a wood shop, you build the wood shop. That's allowed. You can, if she gets a dog and she needs to have a fence there to keep the dog from escaping, that's allowed. Like, this is just part of owning property. I might not like it if my neighbors build some, big house that blocks my sunlight or has a great view into my backyard where I otherwise feel like I want to enjoy some privacy, but I can't stop them from doing it. Like, that's just not an option. So I say I did reasonably rely on the above documents to conclude that no other man or woman or even legal fiction entity, if you weren't convinced that there was some sovereign citizen stuff going on, there's another clue, such as the Strata Corporation, has any claim or right to interfere with the state in which I did acquire the property of I, and that if any problem did exist with regard to the rooftop deck and the dividers, that it was resolved at that time, and I did reasonably conclude that the low-height clear glass divider that was installed at the time I did view the property was the agreed-upon solution by all individuals affected, and the plan was to be implemented by all parties involved. You don't get to decide this for other people who own their own property. I say I do favor the rooftop deck of the property of I over all other areas of the property of I, so she likes her deck. Cool. And as such, on or about February 2023, I did spend about $12,000 on improvements to the rooftop deck. Guys, get ready to drink here. I'm getting ready with my scotch. You should be ready with yours. I did spend about $12,000 on improvements to the rooftop deck in the property of I, which had included a new custom-designed cedar wood divider between the property of I and Unit 305, which is adjacent to the property of I. Are you kidding me? So she's suing to prevent a property divider because it blocks the views. And she's also noting that as part of the basis for her lawsuit to prevent somebody else from installing a property divider that blocks views is that she spent $12,000 installing a property divider that probably blocks someone else's view. This is one of those moments where if a client was coming in and telling me this was their case, I'd be sitting there doing the like Forrest Whitaker looking over the newspaper. So, all right. I say from the time I did acquire the property of I until the 66.5-inch tall opaque glass and steel frame divider was installed, I did very much enjoy the view from the property of I, especially during sunsets when I did meditate on the rooftop deck, looking into the horizon at the ocean, Stanley Park, the mountains, and the beautiful Heritage Burrard Bridge, watching the last of the bumblebees leave for the day, the lavender garden bed, which I did build as part of the improvements to the rooftop deck of the property of I, for the enjoyment of I, and the neighbors of I, and the enjoyment of growth of the bees in the neighborhood of I. Well, I don't think the bees care. I mean, this is kind of like some beat poetry here, but there's a time and a place for poetic wording in a legal filing, but you're kind of ruining it with the whole I thing. It's weird. I say on or about June 4th, 2023, I did hear angry shouts coming from the rooftop of the property of I, and when I did inspect the source, I did see the woman, Colleen McClelland, and her then partner, the man, Dave, take down the low-height clear glass divider without the consent of the man and the woman whose property is adjacent to the property of the woman, i.e., she's not even the neighbor there. She's like further uphill or something. Colleen McClelland, and in the process knocked down other property of the neighboring man and woman. Well, if she broke stuff in that process, the other person might have a claim. But not I, Naomi Arbabi, in our Naomi Arbabi court. I say sometime during July of 2023, I did become aware of the intention of the woman, Colleen McClelland, to install a 66.5-inch tall divider on the rooftop deck at the border of her property in Unit 303, which I did determine will significantly block the view from the property of I. Now there's a solution to this. If you don't want her to install the divider, go and get some sort of encumbrance on the property, like pay her not to install the divider. That's an option. And if you'd walked up and said, hey, I've got $100,000 in cash and this is yours if you agree to preserve my view, she might have said yes. Or she might have said go away, because there's some indication that there are some reasons why they might not have been able to resolve this amicably. You've already got those hints, but we're going to get some more hints. So, I state on July 23rd, 2023, I did knock on the front door of Unit 302, which is the property of the woman, Colleen McClelland, which I did believe at the time to also be where she does live, with the intention to have a friendly discussion, I'm sure. The kind of person who sends you a notice saying that they're going to charge you $1,000 a day is not typically the kind of person who has a friendly discussion with you. With her about the impact of the divider on the enjoyment and value of the property of I. And if you weren't there with like a duffel bag full of cash, then you were really approaching this the wrong way. I state the man, Dave, who at the time did live in the property of the woman, Colleen McClelland, did tell me that he does not have the authority to make decisions on the matter, and that the woman, Colleen McClelland, is not available to talk to I. I say, while I did chat with the man, Dave, I did hear on his phone, which was on speaker. Don't have conversations on speaker when you're around people who might be hostile to your interests, just saying. To the sound of a woman who I did believe to be the woman, Colleen McClelland, ordering the man, Dave, to end the conversation right now multiple times in a tone I did determine not to be friendly. This tells me that there has been some previous discussion and that these two are not on good terms, and that maybe this was not going to be a friendly discussion after all, right? I state on the same day as I did not believe I will be able to talk to the woman, Colleen McClelland, in person, I did write a correspondence to her, which was hand-delivered to her then partner, the man Dave, in which I did ask her to reconsider her plans as it would cause I loss, and I did show the intention of I to reach a balanced solution to address concerns from both sides. Again, if you weren't there with a duffel bag full of cash, you had the wrong approach. And I'm guessing this is when there were notices that said, hey, if you don't do this, I'm going to charge you $1,000 a day, which is not a great way to resolve a problem. So, factual basis. I say I did not hear back from the woman, Colleen McClelland. I state on September 5th, 2023, the woman, Colleen McClelland, did cause a 66.5-inch tall opaque glass divider to be installed on the part of the rooftop deck that is her property. So that would say she's allowed to do that if it's her property, which did cause significant loss to the enjoyment and value of the property of I. Tough. That's part of not owning the neighbor's property, is that the neighbor might do things with their property that you don't like. I state I did not have any further communication with the woman, Colleen McClelland, until after the divider was installed, at which time I did serve her 4 lawful notices. First, I don't think those notices actually seem to contain any law, but, I mean, if they said you owe me $1,000 a day for this, I don't see that that's makes any sense. I don't have a copy of these notices, so, by way of personal delivery and /or Canada Post, and a subsequent notice of claim of I, the service of which, for which she did evade on October 11th, 2023. Evade, maybe. I mean, it can sometimes be difficult to reach people even when they're not evading. We'll see. I state I did press claim in a court of law on October 5th, 2023. So, now, legal basis / lawful basis. This is her whole thing of like, I'm not relying on any statutes or law known to society. We're using the law of the land, which really sounds like freeman of the land sorts of things, but I don't know which particular variety she seems to be buying into. But this does seem to be OPCA argumentation. So long as the claim of I is not unintelligible, confusing, and difficult to understand, it is a little. The style, syntax, or manner in which the claim of I is pressed does not have any bearing on its merits, and it cannot be the basis for determining that a claim is untrue. Fair. All sorts of people might press a claim who might have language difficulties or whatever else. I can't say that any of her claims are untrue on the basis of it. I can say that it's obnoxious, and it does suggest that she's relying on arguments that are not proper. So, the manner in which this claim is brought forward is not due to any animosity towards the legal system or to circumvent a legal channel that may exist for resolving this dispute. Well, if you don't have any legal channels that may exist, then you shouldn't be bringing this dispute. The law is not static, and even if novel, it may successfully be upheld in a fair court. Spoiler alert, this claim is not going to be upheld. I should note, this claim right now, decision is reserved on this claim. They're waiting for a decision, and I suspect the decision is going to be not so much does Naomi Arbabi get to have Naomi Arbabi court. It's going to be how much is the court going to punish Naomi Arbabi for this, and how. And I think that they're going to be putting a decision in writing. That's my bet on this. So I simply wish to press this claim in the private as a woman, as I believe this will achieve a fairer outcome whereby no man or woman who at times acts as an owner of a strata lot, who may not even know a rooftop deck does exist, let alone about this manner, is obligated to make financial contribution towards the claim of I for loss of enjoyment of property, the responsibility for which may in fact lie with the woman Colleen McClelland. This sounds to me like she's saying I might have to sue somebody else as well, and it's her fault. I don't really know entirely. This is not a claim with regard to the strata lot in the land title registry that corresponds with the apartment located at blank. Rather, this is a claim regarding the property of I being that which is proper to I to the exclusion of others in society. I, a woman, have dominion over the property of I to the extent that I do not cause harm to others. But if that harm is just like people don't like looking at your property, then you've got an issue, because let's say your neighbor doesn't like your lavender garden that attracts all the bumblebees. Can they sue you to say stop having a lavender garden? I don't think you'd agree with that. So unless I voluntarily enter into a contract and give authority to another to administer the property of I. She's so close to getting it here. So close. If you were to voluntarily enter into a contract with your neighbor who you're suing to give them, or to give you authority to tell them what they can and can't do on the property, then you'd have a claim. But you haven't done that. And so you don't have a claim. End of story. I claim the apartment located at blank, Vancouver, and the aesthetic appeals in which state that I did acquire the property as the property of I. You don't have a right to prevent other people from updating their property or improving it or changing it in various ways. Unless there's agreements or, there might be bylaws or whatever else. But she's not citing any laws for that. I believe blocking the view from the property of I without the consent of I, in a manner as does the divider in dispute, which does cause I a significant loss of value and enjoyment of property, is administering the property of I without consent. Therefore, to do so is to enter the dominion of I without authority. You might believe that, but you're wrong about that. It's in fact administering the property of Colleen McClelland. And you know who gets to administer the property of Colleen McClelland? Colleen McClelland. She gets to do that. So she's doing that. You administer your property. And if you want to administer Colleen McClelland's property in any fashion, have any authority over it, go ahead and make a deal with her. Give her money. Buy that right. But if you haven't, you got nothing. The trespass is to the dominion of I, akin to other forms of trespass, such as trespass to the person or trespass to chattels and land. The trespass by way of loss did occur when, by causing the divider to be installed, the woman Colleen McClelland entered the dominion of I, she didn't, without authority, whereby she did cause I loss and did not leave the dominion of I when noticed by this unauthorized intrusion 3 times by way of written lawful notices. Now I'm just going to say, I am not the most attractive human being on the planet. And maybe my neighbor doesn't like looking at me when I'm out in the backyard. Maybe I'm out in the backyard not wearing a shirt because it's hot out. I mean, it's not hot out now. It's, December now. It's freezing cold because it's Canada. But let's imagine a time when it's hot out. And if I'm out there and I'm shirtless, the neighbor doesn't get to sue me on the basis of I enjoy my property less because I can see you in the backyard shirtless. It's my backyard. I can be shirtless there if I want to. So, spoiler alert, there will not be a shirtless pic. That's not going to be in this video. So you can keep watching to the end. I'm just letting you know there is no such danger. That's not going to happen. All right. The claim of harassment the woman Colleen McClelland does make against I in her correspondence dated September 11th, 2023 is based on hearsay evidence, most of which is untrue. Most is doing a lot of heavy lifting there. But it basically sounds like Colleen McClelland told her to F off. Stop bothering me. Even if this was a legal complaint made by the legal fiction dead entity Naomi Arbabi, so we're getting into more OPCA arguments. It's not Naomi Arbabi in capital letters. It's Naomi Arbabi in all lowercase letters because that supposedly makes a difference. Spoiler alert, it doesn't. The legal fiction that is the Strata Council still does not. And yeah, we're going to skip over it. She's upset that the Strata Council is a corporation, which, yeah, no kidding. Corporations exist. That's a thing. So, now I'm just going to say, I reached out to Ms. Arbabi to say, hey, do you would you like to give some sort of comment? I thought it was fair to do. She's a member of, she's a member of a law society, not the Law Society of Alberta, but and the Law Society may take some issue with this. I certainly would if I was the Law Society of British Columbia, but they may take some issue with this. So, but I thought, I'll reach out. I'll give her a chance to make some comments here, and we'll see, what she has to say. Maybe she's got some defense. Maybe she's got some sort of thing. And what she told me, and I'm paraphrasing here, I'm not going to pull up her email, but she said basically, listen, after the CBC made their article, I've been getting a lot of hate mail. I've been getting a lot of harassment. This is becoming a public safety issue for me. I'd really appreciate it if you don't publish another story about this. And I mean, sorry, publishing stories is what I do. But I'm not, however, going, I've redacted out all of her information, and I will say, don't contact her. There is no reason to write this person because there's nothing to be gained. So leave her the heck alone. But I will say that this is also a much nicer response than the one she sent to the CBC. And the CBC published her little message there. And she sent the CBC something a little more, I guess we'll call it formal. So notice, to the woman, Bethany Lindsay, who at times acts as a reporter at CBC. I, a woman, Naomi Arbabi, write this notice in regards to the attempts you did and do make to publish a story about I regarding the claim of I against the woman Colleen McClelland. I state any story you do cause to publish about I and or the claim of I without express consent of I, whether or not it claims the name or contains the name of I, will cause I and the claim of I harm. Now I'm just going to say the claim of I was harmed by the fact that it doesn't seem to be meritorious. As such harm is a very grievous trespass, I shall claim remedy in the amount of $500,000 for such trespass, plus $5,000 a day for as long as the trespass continues. Now you note that she says basically, because I have dominion over me, I get to control everyone else on the planet. I get to tell the CBC what they can and can't publish. I get to tell the neighbors what they can and can't build on their property. That's not how this works. I state any further attempts you do make to contact any man or woman who does know I, or does have any relation to I, regarding the claim of I, or in the manner in which the claim of I is presented, will be seen as trespass by way of harm, and or trespass by way of defamation, for which I shall claim remedy in the amount of $100,000 per contact you make, plus $1,000 a day for as long as the trespass continues. I say here and will verify in open court, all herein to be true. So that's a very different kind of response. I'm wondering why I got a less harsh response, probably because she knew I'd read it. And I totally would have, like if she'd sent me this. So there is a possibility she'll sue me for defamation or trespass upon her person. That'll be hilarious if it happens. I can say I don't think anything here is defamatory to the extent I've described these as OPCA claims. I think that's borne out by the conduct. This does appear to fall within the grounds of Meads and Meads, which is unfortunate. I don't know why this lawyer, who I presume was otherwise acting in good stead and so forth, has decided to take this path, which is a path that may well endanger her legal standing and her ability to practice. The Law Society of British Columbia may take a strong view on this. And frankly, I hope they don't disbar her. That's not what I want out of this. That's not what I think would be the best remedy. I hope she gets some help. And whether that's help in terms of legal coaching or help in terms of something else, I hope she gets it. But in the meantime, Colleen McClelland has been harmed by this. You've heard her name about 50 times here, and I will say she did a good job in defending herself here as a self-rep. And she didn't need this attention. she's still getting it because her name is all over all of the news articles and all over the filing. It's not really a way to redact it out in a proper way. It just is what it is. But this is why the courts typically punish this kind of thing, is that it's harmful when you're named in a suit without basis. So thank you guys for watching. I hope you found this to be interesting and educational. I'm going to follow up. We'll see what happens eventually in this story. I suspect we're going to get a pretty strong ruling on this one. And when we do, I'll cover that. And I also suspect that there will be some disciplinary proceedings eventually. And when we do, I'll try to cover that too. So anyway, thank you guys for watching. I hope you had a good scotch during this. I also want to thank my Patreon supporters at the $50 level. Lembas for the Elf, the CCFR, Canada's National Firearms Association, and the Canadian Shooting Sports Association. And at the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Here's a Coin Legal Witcher, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this is armed with knowledge, and enjoy your privacy fences or lavender fields of bees, whichever appeals most.